Hello, everyone. I'm attorney Kelly Longtin from Kelly Longtin Law. And today I want to talk to all of you business executives out there when it comes to your meeting your estate planning goals. Now, as a business executive, you're used to strategizing and creating goals as part of your job. But have you actually devoted the time to strategizing and creating goals to protect yourself and your loved ones? If not, then I want you to listen closely as we address some of the goals business executives often have when they're looking to the future in their planning. The first goal that they often have is to protect their hard earned money from lawsuits and creditors. And although you're usually protected from liability arising from your job, there are some circumstances in which you may be sued. With more responsibility comes a potentially higher risk to your personal accounts and property. Now, one way to protect your personal accounts and property is to make sure that you or your employer has acquired appropriate directors and officers liability insurance. A second way is by using special irrevocable trusts. One type of trust that can be used is a domestic asset protection trust. This is sometimes referred to as a DAPT, and it's one strategy that you can use to protect your money and your property. You give some of your property to this trust, which is irrevocable and thus cannot be changed. The trustee can potentially make distributions to you, thereby allowing you to continue enjoying some benefits of the trust property. However, the trustee in most cases needs to be an independent trustee, someone who's not related or subordinate to you or any other beneficiary, and who will not inherit anything. Now, the goals of ADAPT are to allow you to fund the trust with your own money and property, maintain an interest in the trust as a beneficiary, and protect that money and property from any future creditors. Now, DAPTs work on the legal principle that someone cannot take away from you something that you no longer own. When you transfer property into a DAPT, you're actually making a gift of it to the trustee, so the person you chose to manage it, on behalf of the irrevocable trust. Now, keep in mind the laws governing DAPTs, they're continuously evolving and they're very, very state specific, as they're not allowed in each and every state. So it's important that you work with an experienced estate planning attorney and have this discussion with them. Another type of trust that can be used is a lifetime qualified terminable interest property trust, or a QTIP trust. And this is an irrevocable trust created by the trust maker's spouse, who usually has more money and property for the benefit of the beneficiary spouse. Now, the trust maker's spouse can create and fund the trust without using any gift tax exemptions by relying on the unlimited marital deduction, which allows spouses to gift money and property to each other without any tax consequences. Now, during the beneficiary spouse's lifetime, they will receive all of the trust income and may be entitled to receive trust principal, but for limited purposes. When the beneficiary spouse dies, the remaining accounts and property will be included in their estate, thereby making use of the beneficiary spouse's otherwise unused federal estate tax exemption. If the beneficiary spouse dies first, the remaining trust property can continue in the Asset Protection Lifetime Trust for the trust maker's spouse's benefit, subject to any applicable state law, and the remainder will then be excluded from the trust maker's spouse's estate when they later pass. Another type of trust is the Spousal Lifetime Access Trust, or what we call a SLAT, and that's an irrevocable trust created by the trust maker's spouse for the benefit of the beneficiary spouse. Now, the trust is used to transfer money and property out of the trust maker's spouse's estate. This strategy allows married couples to take advantage of their lifetime gift and estate tax exclusion amounts by having the trust maker make a sizable permanent gift to the SLAT that decreases the value of their estate while maintaining some limited access to the money and property that is gifted for the beneficiary spouse's benefit. The trust maker's spouse gives money and property of which they're the sole owner to the SLAT for the benefit of the beneficiary spouse. If the couple resides in a community property state, they will likely need to convert community property into separate property through a partition agreement. The trust maker's spouse reports the gift on a gift tax return. The beneficiary spouse can receive distributions from the trust, from which the trust maker's spouse may also indirectly benefit. Upon the death of the beneficiary spouse, the trust assets are transferred to the remaining trust beneficiaries, usually children and grandchildren of the couple, either outright or in trust. Now, when considering these types of trusts, it is critical that you work with an experienced estate planning attorney. These trusts usually have very strict requirements that must be met in order to provide you with the protection that you're looking for. It's also important that you understand just how much control you'll be giving up in order to protect your hard-earned money. So I know that you've worked hard to accumulate your own wealth, but you also may want to put protections in place when it's time to leave it to your beneficiaries and your loved ones. So I want to talk about a couple of trusts in which you can implement in order to do that. The first is by leaving their inheritance to a beneficiary in a discretionary trust. And a discretionary trust is just a trust in which the trustee uses their discretion as to when distributions of money or property are made to or for the benefit of the beneficiary. Because your beneficiary is not guaranteed and they don't have a right to demand a specific amount of money or a piece of property, those funds can be better protected from the beneficiary's creditors and predators and even a divorcing spouse. A discretionary trust can be included as part of your irrevocable living trust, your last will, or even a separate trust in and of itself. Another type of trust is an irrevocable life insurance trust, or an ILIT, and that's another valuable strategy that protects your loved one's financial well-being. The ILIT owns a life insurance policy on your life and receives the death benefit upon your passing. Because the death benefit is paid to the trust instead of outright to your beneficiaries, this type of trust can protect the death benefit from creditors of your beneficiaries, lawsuits, or future divorcing spouses, as long as it is properly created to remain in trust and is not distributed to the beneficiaries outright. Beyond asset protection benefits, a properly structured and executed ILIT can also significantly reduce future estate tax liability because a life insurance policy is owned by the trust and payable to the trust and will not be taxed as part of your estate upon your death. Another type of trust is a standalone retirement trust. Now, a standalone retirement trust is just a special type of trust, separate and distinct from your irrevocable living trust, that is designed to be the beneficiary of only your retirement accounts after your death. Now, when drafted as an accumulation trust, SRT protects the inherited retirement account from the beneficiary's creditors, as well as guardianship or probate proceedings. An accumulation trust requires that any required minimum distributions that are taken from the retirement account are reaccumulated back into that trust corpus. Similarly, if the retirement account must be liquidated, which is usually the case 10 years after the original account owner's death, the funds remaining in the retirement account are accumulated into the trust corpus, not given outright to the beneficiaries. Now, while there can be drawbacks to an accumulation trust, such as distribution being taxed at the trust income tax rate, which is often higher than that individual beneficiary's tax rate, some people find that the benefits definitely outweigh this potential burden. Now, an SRT drafted as an accumulation trust ensures that the inherited retirement account remains in the family and out of the hands of a child-in-law or former child-in-law. It can also enable proper planning for a disabled or a special needs beneficiary. Now, like most of us, you probably want to pay as little tax as possible. And depending on what other accounts or property that you own, you may need to start strategizing with a tax professional about the best way to save on income taxes. Also, if a stock option was presented to you as part of your compensation package, you may need professional guidance before taking any action on that. Now, depending on the type of stock option that you were given, it may need to be reported as taxable income once it has been granted, and the tax might be due when you decide to sell the stock. Because of the various tax implications, it is important that you work with a professional to plan if and when you would like to exercise your stock option and when you sell the stock. Now, estate and gift tax should always be in the back of your mind when you start accumulating accounts and property. Now, depending on how much you make each year and other accounts and property you own, estate tax could become an issue for you. Although the rate is high right now, it's about 12.92 million per person in 2023. This rate will sunset on December 31st of 2025 and then return to $5 million, of course, adjusted for inflation. Now, it is possible that while you may not have an estate tax issue on December 30th of 2025, you might just have one on January 1st of 2026. Now, if you work for a large company in your area, or if you're employed by a Fortune 500 company, keeping the details of what you own and who will receive it private may be critical to ensuring the privacy of your loved ones. If this is something that is important to you, you need to update your estate plan, probably specifically your trust, or even establish one. Without an estate plan, your loved ones are going to have to go through the probate process without a trust as part of that, as part of your estate plan. Now, probate is a public, time-consuming, and costly process of gathering all of your accounts and property and distributing them to the appropriate individuals. This process requires that important information become part of the public court record, such as an inventory of everything you owned, a list of all of the people receiving your money and property, and how much each will be receiving. This means that anyone with a few dollars and some free time can either go down to the courthouse and get these documents or get them online if your county provides that service. Also, without any plan, state law will determine who receives your money and property, how much they receive, and when they actually receive it. Now, if you have a will in place, you can dictate who will receive your money and property and how much each person will receive and then how they will receive it. However, that process of gathering up everything and distributing it to the appropriate people is still overseen by the court system, and all of the information may be available to the public. Contrary to that, if you have a trust in place, you can specify who gets the money and property in the trust, how much they'll receive, and when they'll receive it without any court involvement. In the trust agreement, you appoint a trustee that will be in charge of managing everything and working with the named beneficiaries to ensure that your money and property are distributed as you intended. Now, in most cases, the trust or any additional information, such as an inventory or an accounting, will not be provided to the probate court, which means that the public will not have access to it. With the many options available to you, it's important that you have someone that you can trust. So you want to follow up with your qualified estate planning attorney so they can talk to you and help you meet your financial goals and your estate planning goals. So I hope you found this beneficial. This is specifically tailored for all you business executives out there, and I want to thank you for watching. I'm Attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families in both Massachusetts and New Hampshire.